Right, part three, Kyle Rittenhouse's hearing. This is to discuss motions filed by both Binger and Richards, although Binger has the lion's share of the motions and gets the lion's share of the ridicule. There are two issues that are going to come up before the judge here. One is the insane list of 170 something witnesses that Binger put in the discovery list. And the other one is the whole CBS looting show. By the way, I am not feeling well. I don't know if my voice is carried out correctly or not. It sure doesn't sound right because my ears are plugged up. At any rate, Binger isn't going to do any better here than he did before. Hello out there. I'm trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dredd Show.
Look at the expression of Kyle Fizzy. He's looking over at Binger, and he's going to smile at him. He knows what's coming.
I think the last thing was, the state's witness list. And I have to say, when I saw it, it did bring to mind the very case that the defense cited, State against Irby, when the discovery first came in, and I'm old enough that I remember when they changed the law, and the prosecutor made a heavy list on the accused of every name in the community or something, and Supreme Court says you can't do that. So I don't want to take too much time on it. Have you narrowed down this 175 witness list?
I have a feeling there was an ass chilling that took place behind the scenes. They probably brought in all the lawyers, and Judge Schroeder laid it out very clear. This list of 174 witnesses is absurd. And he probably told him, you had better whittle this thing down.
Judge, we were on the motion with Mr. Black.
Oh, we were, but now that I'm talking about this...
And then we skipped a couple extra.
We did, and we'll come back on Mr. Black. I must have turned my page when I took the break. Yeah. But...
They don't want to talk about this. We were talking about Mr. Black. Can we go back and talk about Dr. Black, please? Please? No, we're going to talk about this witness list.
Let's talk about the 175 witnesses. Has that been slimmed down?
Yes, so Attorney Binger did send the numbers of individuals that we are more likely to call.
Okay.
That, of course, may change as we get closer to trial, but we have narrowed it down in private, of course. We do want to be more expansive on our list, just in case something comes up that was unanticipated, and that way there's not a dispute at trial that a witness was not listed, but we have privately narrowed it.
Yeah, okay, this happens at every trial where you could have people that you didn't think were going to be included, and you have to include them. That causes complications. Sure. Why in this particular trial did you name 174 people? I'll tell you why in a moment.
Satisfactorily?
On one aspect. They put it down to, I believe, if I counted correctly, 27 witnesses. Okay? And I can live with that, but they have not provided addresses.
Well, wait a minute now. That I noticed that they claim that they would provide them to you so they didn't get posted on the internet. And did you say, okay, we'll take that, or did you...
I was told by Mr. Binger, they're in discovery, find them. And...
Is that true?
I rudely told him to go find them.
Emailed Mr. Richards yesterday. I gave him a narrowed down list. I said the addresses that we would be providing to him would require us to go through the same 400 plus pages of police reports.
What does the statute say?
The statute does require us to provide addresses in a written filing with the
court. So I can expect that'll be done by Monday at 5.
Would you like us to file with the court?
I understand your desire to keep it from being filed, and I think that If the defense objects, we'll have a discussion about it. But no, you can do what you did, but you need to send him the addresses.
So they had 170 something. He finally had to whittle it down to 27. And then, of course, Richard says, okay, what are their addresses? According to Richards, Binger came in and said, well, they're in discovery. Go find them yourself. Of course, discovery is like 400 pages, as Binger is claiming. Now Binger is claiming, well, I didn't provide the addresses because it's so hard. There's so many pages. This could take us a long time. And the judge says, what does the law say? What does the law say? The law says you got to provide the addresses. I want it in by Monday, 5 p.m. The judge knows what he's doing here. Now you may be wondering, what's the harm in naming so many witnesses? Well, for each witness, the defense has to investigate. They have to get testimony from friends and all that. It's very expensive. And therefore, it was to Binger's best interest to provide this huge list to break the defense financially. Then, when trial comes, he can simply say, well, those others, we didn't need them after all. So that's what was going on. The judge saw it, and the judge is not happy. He's smiling, but he's not happy.
And what
By 5 o'clock on Monday.
my biggest concern is updated. This has been 13 months ago. People move, things like that, and obviously they're going to have the most up-to-date addresses to get people under subpoena and things like that.
Okay, so that's it. Now we were talking about expert witnesses. Now let me just say that my last acquaintanceship with this issue was that, and this is a little bit different, some of the issues that are discussed. But ultimately what this witness is being called for, Mr. Black, Dr. Black, what is it? Dr. Black. What Dr. Black, what the defense proposes to bring Dr. Black in is ultimately to show that the defendant's conduct conformed to the law of self-defense.
It's more what I would characterize as use of force. And one of the things that we've been addressing, it was said earlier in this, is how he handled his firearm, whether what he did with his firearm was reasonable. His reaction times to being attacked by Mr. Rosenbaum. He also has the ability through his software to break down every incident frame by frame, which allows him to put very accurate timelines on each of the shooting aspects. One of the things that I'm sure the state is going to...
You know what, I'm going to interrupt you right now, because I think we need to have a full-fledged Daubert hearing on this. And I need to see the report. That would be on page 1, as I have not seen the report. Now, what are the 28 pages? I haven't seen it. I don't know what it says. And I'll have a better understanding of what you propose to prove. Certainly the law is that when it comes to use of force, when it comes to use of force, I'm the expert. Not because I'm so bright, but because the Supreme Court says I'm the expert, and I'm the only one who's going to be defining what is reasonable under the law. What constitutes self-defense. So I'm not going to have competition in the courtroom, so we're not going to have any evidence on that subject. On the other hand, just as in sexual assault cases, state brings in witnesses to prove a variety of things from people who are experienced in the field. So this use of force may have kernels that would be admissible, and I won't know that until I see the report and have the hearing. So before we leave, we'll have a Daubert hearing set.
When it comes to self-defense, the judge is being very clear here. There's matter of evidence, there's matter of law. and it comes to evidence that's in the jury's purview, the legal expert here, Dr. Black, can testify on those kind of issues. When it comes down to what's the law, he cannot. The judge has to be the one to decide that. And how the judge is going to convey that to the jury remains to be seen, but most likely in the jury instructions. So he doesn't want the expert getting on there and telling the jury what constitutes self-defense and what does not.
So do we need to take this up other than that today?
Is the court intending to hold that hearing prior to trial?
I do. And then, the materials that were filed yesterday afternoon, do they pertain to expert witnesses also?
There are notices of experts.
Oh,
There are three of which were already on the witness list and then already have the reports.
okay.
We have the reports.
Is there going to be an issue with respect to that?
As to them, no. The third one, I believe, is self-defense use of force expert.
I didn't hear the last thing you said.
Self-defense use of force expert,
Okay.
much like Dr. Black.
State's got one too?
Yes.
Okay. All right, well, we'll have a common Daubert hearing for them.
And Your Honor, we don't plan on calling ours, obviously if the defense, if the court grants our motion to exclude Dr. Black's testimony, then we won't need our witness either, but we have to plan for the contingency if the court rules otherwise.
Okay, next.
Okay, so Binger has filed a motion to have Dr. Black stricken from the witness list. We'll see.
Motion to compel discovery about donation lists, and is this still an issue?
It is.
Okay, now, the defense statement by Mr. Richards that I read was that he doesn't have any access to any information from Free Kyle USA. And are you disputing that?
It's run by the defendant's mother, so yes, I am.
It is.
The defendant's mother is not a party to this action.
Well, the defendant's mother is someone who the defendant can obtain information from quite easily.
McGee?
Your Honor, this is within...
Binger, he's got you. Stop it. You have nowhere to go here. You should have realized from the outset that the judge was not going to grant your motion here. And now you're going to plead that because the third party is a mother of the defendant, an adult, that somehow the defense should be able to extract information from her. No one falls for this. Why are you pressing this?
This is not a third party. This is not an accountant. This
It
is
is
not...
a third party.
It's his mother.
It is a third party. Okay? He's telling you. What are you doing?
Your Honor, I submit that it's a reasonable request of the defendant. He's the beneficiary of all of that fundraising. He is the person. It is called Free Kyle USA. He's Kyle.
What if it was called Free Binger USA? What then?
So this is not an independent entity. This is something that they have the ability to access. And Your Honor, quite honestly, if the shoe were on the other foot and there was some sort of fundraising for the state in this prosecution and we didn't turn that information over, it would be per se reversible error. So we're entitled to the
I'm telling you,
same...
by what authority can I order a citizen to provide, that you can subpoena, by the way, to provide material to the defense attorney or to the defendant that is her proprietary information and command them to cough it up?
The judge is right. He can subpoena this information, maybe. But Binger doesn't want to do that. He wants to get it from Richards because this is all about a battle between those two competing law firms. Binger's taking this thing to the personal level with Richards.
The law is I can make them produce what they have. I cannot compel them to produce something, and nor do I know of any authority that I can make her give it to them. Is the law different from what I've stated?
Your Honor, will you issue, if the state supplies you with subpoena, will you issue subpoena then?
Well, issue the subpoena, then you'll find out. The judge can't answer that.
I'm not going to give an advisory statement. I'm going to tell you that I do not think I have the legal authority to compel the defendant to procure information from somebody else who owns it and provide it to you or to the court even. I don't think I have that authority. Now, whether it can be subpoenaed, and you ask me to sign the subpoena, can't you do that?
We will pursue
The
that.
defense can't do that. They need my approval. You
Yes, he could do that, but that would mean not being able to order Mark Richards around. Binger, you just kind of wonder what he thinks at times. Suppose that the judge told Mark Richards, I'm ordering you to get that witness list, to get that donor list from Kyle's mother. What if she told him to go pound sand? Screw you, I'm not going to give it to you. Are you going to hold Mark Richards in contempt of court? What can he do at that point? Do you think he's going to be able to call the sheriff and go into that lady's home and get that donor list?
can subpoena on your own signature.
The entity may be located in a different jurisdiction, so we may need this.
Oh,
court to
well, okay.
authorize it, so that's why I
Well,
asked,
maybe
but-
we should we'll just talk about it a little bit then, if this is something that's going to come up. No, I'm not going to talk about it a little bit. I'll save that for another day if we need to. Then you also asked for the Fight Back Foundation. And you want a list of their donors. Do you have that?
No.
No, you don't have it. Now he looks at Binger like, okay, let's hear your bullshit.
Your Honor, just,
Same issue.
and Fight Back is represented, it's run by Linwood and a board. We separated from them in late December 2020, early January 2021. I tried to get the exact date, but I received two different answers, so I don't want to give a specific date. However, there is no contact with that organization anymore. I know that at one point, some of the civil lawyers involved in this sought to seek that information because they believe there hasn't been a full accounting for the funds that were given. There is no communication or cooperation. I believe Fight Back is in Texas, incorporated in Texas. I don't have it. I've never had it. I've never requested it.
Pretty clear. They don't get along. And so even if he wanted to get that list, Fight Back's not going to give it to them.
Same issue.
Understood.
Okay, and I'm going to pass on that.
Binger says, okay, you got me. He finally wised up. Actually, I'm a little bit surprised. I thought Binger would put up a fight there, be Binger.
Well, I'm just going to, I'll deny the motion at this point. State's second motion to omit other acts evidence, reporting about an incident that is claimed to have occurred on the 10th of August involving an incident outside of CVS.
Your Honor, there's no dispute the incident occurred. The defense motion has acknowledged that the defendant was there, that it's his words, that he essentially made a statement that he wished he had the same rifle that was used in this incident to kill two people, so he could shoot individuals coming out of the CVS pharmacy. This is
Okay, the very fact that they know it was Kyle, believe me, if they asked Binger, is that Kyle? Binger would have said yes, but Mark Richards would have said, we don't know, right? The fact that Mark Richards is saying that it was Kyle indicates that he has a little choice but to own up to it. That means that the information was given to Mark Richards from a very reliable source, probably Dominique Black, but it also could have been lifted from Dominique Black's cell phone during a search warrant of some sort. But most likely it's Dominique Black that gave them the information or had it taken from him. Now you may be wondering, well, What about Dominic Black? Hey, if Dominic Black gave them that information and they're going to get their motion struck down, good for Dominic. Well played. I have no problem with it. I know what you're thinking. Oh, come on. That's betrayal. That's his friend. He's facing some serious time in prison. I would not expect him to do that for somebody.
15 days prior to the August 25th incident, so it's very close in time. And it's, again, goes to the issues we talked about earlier. This is a continuing motivation here. The defendant is irresponsibly using his firearm, or threatening to use it, I should say.
He's irresponsibly using a firearm. Okay.
Talking about using it to shoot individuals who he believes are ostensibly committing a shoplifting offense from CVS in Chicago. He has no ties to the business. He has no role to play there whatsoever, but yet he wants to launch himself into the middle of it with...
Yeah, like good citizens often do. They see crimes taking place. They want to get involved to stop it. Just because he doesn't have any connections to the people involved or the businesses doesn't make his actions wrong.
This same gun. And it's similar to what we have on August 25th, Your Honor, where the defendant is in our community with that same gun. And using it in a manner that I think is legally unjustified. So this goes exactly to his state of mind in terms of his understanding of use of force, his understanding of self-defense.
Understanding of self-defense. He's not claiming any kind of self-defense when it comes to the CBS deal.
Self-defense of property by use of deadly force is not allowed, and that's very clear. So this is a completely unjustified use of a weapon. It's the exact same weapon that we're talking about here. So for all those reasons, Your Honor, I believe that this is admissible. Other acts evidence, I think it goes to his state of mind, and I think that's the crucial issue in this case.
This is one where I thought that he might have had a sliver of a chance of actually getting, but he bungles it so badly, he loses out.
Thank you, Mr. Shropsy.
Judge, Mr. Binger describes it as an unjustified use of a weapon and a threat. I would submit to you neither one of those things are actually true. I don't know if you've seen the video or not. However,
I have.
Okay. So it is a video of him sitting in a vehicle, having a conversation with, I believe, Dominic Black. The state in their other acts motion says the three things that I think you need to think about, which I believe to be are untrue, which is the state says we would like this admitted for the following reason. The defendant's understanding of the proper use of his AR and of deadly force is crucial to this case. The video demonstrates that the defendant was eager to use deadly force in an unlawful situation. The video demonstrates the defendant fervently sought to insert himself as an armed vigilante into situations that had nothing to do with him. Finally, and perhaps most importantly, the video proves the defendant was ready and willing to use deadly force in situations where it was completely unjustified. That video doesn't show any of that. He didn't have a weapon. He was sitting in a vehicle having a conversation with someone else. He never made contact with those people.
Notice the way he approaches the judge this way. He comes in, he's drawing the judge in again. This guy is really good.
At CBS. If you watch the video, they don't know, presumably, they don't know he's even there. He doesn't even step from the vehicle to verbally confront them in any way. He doesn't do anything. He doesn't open his window. He doesn't honk the horn. He does nothing but passively sit and watch what's happening. So to say this video demonstrates his willingness to insert himself into these situations, that's untrue. He didn't insert himself. He could have. but he didn't. If you look at the actual situation and you compare it to, and I want you to know this, Judge, there are situations that I think this would be relevant, okay? And it would be admissible. If he had fired a round at someone who was simply damaging property, I think we might be in a different spot. That didn't happen. Joseph Rosenbaum, Gage Grosskreutz, and Anthony Huber were not, as far as I can tell, were not looting anything that night. It is indisputable that Rosenbaum was a rioter. Not debatable. And it is not debatable that Gage Grosskreutz was armed with a Glock pistol in his waistband. That is not debatable either. Does the fact that he made that statement 14 days prior and took no action, didn't have a gun, didn't get out of the car, didn't do anything, does that make it more probable that this wasn't self-defense? I would submit to you the answer is no, because, as I've said to you before, this wasn't him taking pot shots at looters. Mr. Rosenbaum was chasing him. That started the whole thing, right? So when you're looking at it, this is Sullivan to a T. Words, the reason Sullivan it wasn't admissible is, in one instance, it was words, and the other instance, it was violence. In this instance, it's words on August 10th, and on August 25th, it is not debatable that there is violence. It, as I said, doesn't go any further to make a determination as to whether or not that was in self-defense. If he was claiming something else, if he was just saying, my gun accidentally fired, or I was shooting at a looter, I would submit to you that I'd be in a different spot than I am right now. But I think based on the information that you have, based on when you're doing a Sullivan analysis, and actually the fact that we're talking about words versus action, and it is a self-defense claim, as opposed to any other type of defense to the charge. When you compare those things together, it is not relevant for purposes of making a determination as to the ultimate issue in the case, and that is the reasonableness of his actions on August 25th. You can do the analysis as you've already done on the probative value and substantial prejudice as that would occur. I certainly would argue, Judge, that words don't equal action, and just to admit it, to say, look, he's a guy that would shoot at someone. That's propensity evidence. That's not what happened here, frankly. It's not close to what happened here. And for those reasons, I would ask the court to deny the motion.
I want to respond very briefly, Your Honor, because there is an actual action he takes.
Oh, no. Binger. Oh, no, don't go here. Binger, stop it. He's got you. Go sulk off in your corner. Don't make a fool out of yourself. Well, here we go.
At the CDS incident, and that is he does call 911.
Oh, jeez. Everybody in the courtroom must have just groaned. Like, that's it? That's what you're going to hang your hat on? The fact that the defendant dialed 911? At this point, the judge is thinking, wait a minute, Binger, you're the prosecutor, right? You're not the defense attorney.
Using his personal cell phone while he's watching this incident. Now, he doesn't know what's going on. He doesn't know what these people are doing. He's sitting in a car across the street. He doesn't talk to anybody. No one asks him to call 911. He thinks he sees a crime. His response, in part, is to call 911. His response is also to say, I wish I had my gun so I could shoot these people. Now, we're lucky he didn't have his gun.
Why do you assume that? This is conjecture. If he had his gun, he would have shot people. You don't know that. That's why words do not equal action.
But the standard for other acts isn't that we have to present to the court an exact scenario that matches the exact crime that the defendant is being charged with.
That's true, but you have to be within the same zip code
As the other act. That is not the bar here. Nor is the fact that these are simply words a bar to admission. For example, if the defendant had said, I'm going to kill Joseph Rosenbaum 15 days before August 25th, and then kills Joseph Rosenbaum, that would be admissible.
That's true, because there'd have been a strong nexus between the words and the actual crime. That's not the case here. You're highlighting the reason why your motion should be dismissed.
So the fact that it's words, the fact that it's not action, does not bar the admissibility of this. The key issue in this case is the defendant's state of mind. What was his intent on the night of August 25th? What did he intend with that gun? How did he interpret the threats that he thought were coming towards him? How did he react to them? Were they reasonable? How do we determine what's reasonable? We look at the incident, we look at the defendant's state of mind, we look at his motivations, his intent, his knowledge, all of those things. We don't have a lot of insight into that. The defendant has not given a statement. We don't have a lot of history here, one way or the other.
Oh, it's too bad. That's your problem. That's not the court's.
I have sought in my prior other acts motion, and the court has ruled on it, to give some context to the jury as to the defendant's state of mind. This is also part of that. And I acknowledge the court's ruling on my prior other acts motion. The court has denied that, made some rulings on that. This is unquestionably.
Did you acknowledge the fact that you made a fool out of yourself?
A far more powerful other act. It is a more relevant one. It goes more strongly than even the prior motion to the Sullivan factors, to the relevance, and in terms of undue prejudice here, that is absolutely not even a factor here.
So in other words, this one is even more crucial. Every time you raise a motion, it's always crucial. And every time you get denied, the next one becomes even more crucial.
Because we're talking about the same gun, we're talking about the defendant's own words, we're talking about close in time. So it's not a question of undue prejudice here. This is giving the jury an honest insight into the defendant's state of mind to determine what his subjective beliefs were, to determine what a reasonable person would do. This is information the jury should have when making those determinations. Now, the court can make a limiting instruction on it. The jury can give it the weight that they feel that it deserves. But
And again, he falls back on this. Well, let's just tell him everything, and then we can tell him what to ignore.
they deserve to hear the truth about what the defendant was thinking and what his intent was with this weapon. And let's put this in a larger context, Your Honor, because this was a weapon that he purchased a few months prior. I believe it was in May of 2021. My understanding from the evidence in this case is that he had gone up somewhere in Wisconsin, fired that weapon one time, ever,
So?
prior to August 25th. So he's here on August 10th. He's wishing he had the gun. He doesn't have the gun. It's not in his possession because he can't take it to Illinois. He doesn't have a firearms owner ID card. He can't get one because he's not 18. He's storing the gun at a friend's house here in Kenosha.
Yeah, reasonable things to do. In other words, he's trying not to break the law.
And he's limited in terms of his access to it. He's shot it one time. He wishes he had it on August 10th because he would have used it if he had it that time to stop what he thought was a crime in progress. And then on August 25th, we know what he did with it. So his relationship with that gun, his desire to use that gun, his inability to access that gun is all crucial here in terms of the context and the state of mind here.
If Kyle only fired that gun one time, he handled that gun pretty damn well. Amazing.
When you put it in that context, it becomes even more relevant evidence, and I think the jury is entitled to hear it. Thank you.
Thank you.
The jury is entitled to hear it. Jury is not entitled to hear anything.
Once again, I think the evidence is too dissimilar. It becomes propensity evidence. The effort, it seems to me, is being made to show that the defendant is a violent vigilante, and he's willing to employ violence, and he's willing to take matters into his own hands. Although certainly the I think I heard now for the first time that he called 911. So,
Yeah, thanks to Binger. That was real smart.
he didn't take matters into his own hand. He called the proper authorities. That was not an issue on the date that the incident here in Kenosha occurred, because he could have called 911 all he wanted. There was general lawlessness in the community, which was out of control. And so whether he was motivated towards acting as a vigilante in this case, I don't know. That's for the jury to decide, or whether, if they get to that, if it's necessary for them to decide it. But the acts are totally dissimilar, because in the one instance, he's observing what he believes to be a crime being committed. He makes some threatening statements, for sure, statements. And then the one action that he takes is one that is a proper action. The incident in Kenosha, from what I've heard, and I haven't heard what the defense has claimed here, contradicted, is that the incident, I don't want to say started, but the last moments of part of the shooting, it consisted of the defendant taking a fire extinguisher to try to assist with extinguishing some blazes. I know that, there was the night that the...
By the way, the judge stammers around a lot. He's very careful in his choice of words. This is actually a good thing. He's not real smooth, but, it doesn't matter. He's not an actor.
Furniture, I think it was a furniture store on 60th Street, and the Department of Corrections building. The firefighters never showed up. I mean, you could call 911 all you wanted. There was no law and order. And I'm certainly not condemning the local authorities here. The police and the fire and the sheriffs acted very bravely, and the people who assisted them. There was simply inadequate personnel to deal with the emergency here. So whatever the defendant's conduct was has to be examined in that light. And whether he assumed a role he ought not have, or whether he did, that's for the jury to sift through. But an incident that occurred in a peaceful setting, where he saw something he believed to be criminal taking place, and made some really threatening remarks. Threatening is probably the wrong word. There are certainly statements that could be illustrative of his will and wishes at that time, for sure. And then ultimately took the correct action, versus an incident which is ongoing here in Kenosha in a lawless setting, in which he is also engaged in conduct which in and of itself doesn't appear to have been unlawful, for him to be trying to extinguish a blaze. And then what followed after that, and as I say, I haven't heard a contrary side of it.
I'll give you one, Your Honor.
No, go ahead.
Yeah, because that's maybe I haven't made this clear in my motion, but...
Well, that's your fault. That's the reason why we have to go to law school and learn how to write.
In both of these situations, the defendant is taking it upon himself, taking the law in his own hands.
Taking the law in his own hands by calling 911. Okay, this is going to get good.
Under circumstances where he doesn't know the full facts, he is making assumptions.
We all make assumptions. We see people, what we think are robbing a store. They have, let's say, mask over their head, and they're running out of the building. There's a burglar alarm going off. We make assumptions about what we're seeing. Certainly the people that were chasing Kyle and attacking him made some assumptions, didn't they?
On August 10th, he's making an assumption, seeing people coming out of CVS, and he thinks they're robbers. And he's talking about taking the law in his own hands by firing off rounds with his AR-15. This is before he calls 911. So his first instinct is, I'm going to stop this with my gun by killing these people, which is completely unlawful. He's not allowed to shoot and kill. Even police would not be allowed to shoot and kill people coming out of CVS pharmacy, even if they just committed a shoplifting. It is not allowed.
You tell me exactly what he said, because I don't remember the
He
statement.
said, "Bro, I wish I had my AR. I'd start shooting rounds at that."
Yeah, but if he had his AR, he probably wouldn't have. It's just tough talk. We all say these things. If I had a tank, I'd run these protesters right over. Yeah, right.
Okay,
So
go
he is
ahead.
clearly
Okay, go ahead.
to shoot at these individuals with an imperfect understanding, an assumption. He has no actual knowledge of what's going on. He makes an assumption. Now, on the night of August 25th, I believe the evidence at this trial will be slightly different than what you've heard. And I do want to contradict the rendition that has been presented to you by the defense. The defendant that night was ostensibly trying to protect a car source location at 59th and Sheridan Road from people damaging that property. He is among a group of people who have stationed themselves with open firearms, most of them carrying these type of AR-15 rifles openly slung around their shoulders. Many of them are on the ground, some are up on the roof. This is sending a message to anyone: stay away from this property, we are armed, you don't want to mess with us. And they essentially are successful in that assignment. That property is undamaged that evening. There comes a time, though, when the police use armored personnel carriers, Bearcats, and other armored vehicles to push all of the citizens that are out on the streets south of that location. The police established a barrier at 60th and Sheridan, and essentially everyone is moved south of that and can't get back to 59th. So this car source location, they've now successfully protected, and everyone's gone. So there's no one to threaten this building anymore. However, prior to the police establishing that cordon line at 60th, the defendant and another armed individual, part of this group, go down to 63rd and Sheridan, the other car source location, because they hear whoever was supposed to guard that location is no longer there anymore, and we need to go down there and check it out, maybe protect it. So they go down there. And at some point they try and come back, only they can't get back because the cops have blocked off 60th and Sheridan. So now the defendant is trapped on the other side of that line. He's trapped with this other individual.
Through no fault of his own.
He can't get back to the rest of his group. His job that night is to protect 59th and Sheridan. He can't do that job anymore.
That's right, but he also had a job of going out and helping injured protesters, as he said on video.
So what does he do at that point?
Does he go out and shoot looters? That's what the claim is here. He went out and went looking for looters to shoot. Let's see what he actually did.
Go home? Does he say, okay, it's 11:30 at night, my job is done, I'm gonna get out of here? No. He takes it upon himself to run around in a hostile crowd, a lawless situation, a chaotic situation, with people who have guns, people of varying motivations. He's openly carrying an AR-15 or a Smith & Wesson M&P 15 assault rifle type weapon. He's running around and he's trying to stop people from doing things because he thinks what they're doing is illegal. And maybe
I would have stopped him and I said, look, I'm tired of hearing you say running around. Describe what he was doing. If he was walking, say walking.
it is, maybe it isn't. But at some point during this interaction, he gets into a confrontation with Mr. Rosenbaum and is essentially trying to stop Mr. Rosenbaum from doing what Mr. Rosenbaum's doing. Now that...
You're going to tell this to the jury? You're going to tell this story to the jury? Okay.
That's not Mr. Rittenhouse's job. He's 17. He's not a law enforcement officer. He's not deputized. He's got no training. But he takes it upon himself to take the law into his own hands to confront Mr. Rosenbaum because he thinks Mr. Rosenbaum is doing things he shouldn't do. And this fire extinguisher that he's carrying it along, pursuing Mr. Rosenbaum with the intent of stopping Mr. Rosenbaum from doing whatever he was going to do. And that's what leads to that confrontation. The similarity between August 10th and August 25th
is non-existent.
Is in both situations, the defendant took the law into his own hands, or talked about taking the law into his own hands.
Or talked about taking the law into his own hands. Action is not the same as words.
With the same gun to stop things that he thought were going on, that he didn't think should be going on, and he appointed himself a vigilante, taking the law into his own hands in those circumstances. They are identical in that respect.
You know, this thing about Kyle, trying to stop somebody from arson is not going to sell to the jury. They had their community burned down. It was people like Joseph Rosenbaum who did it. And now you're trying to tell the jury that they should convict the kid because he tried to stop them from burning the community down? That's your angle?
And when we talk about the defendant's motive and intent that night, this is crucial to the case because that is exactly what is going on. And the defense will have testimony on this. They will say, Mr. Rittenhouse was trying to stop these people. He was concerned about looters. He was concerned about fires. He's going to put them out with a fire extinguisher. He's going to stop these bad people from doing bad things.
That's right. The defense is going to make that argument. They're going to claim that Kyle took out efforts here to try to stop people from doing illegal things. You're also making the claim that Kyle went out to try to stop people from doing illegal things. Why do we need the CBS footage? Both sides agree.
Things, or so he says. Except that that's not his job. Nobody asked him to do that. He's got no legal authority to do that.
Whether it was his job or somebody asked him to do that, or he had no legal authority to do that, is not uncovered by the CBS footage. The CBS footage does nothing about those particular statements. And by the way, it doesn't have to be his job.
His job was done. 59th and Sheridan was no longer in any danger. Go home.
But he wanted to go out and help injured people, and you're saying he can't do that. Okay, you tell that to the jury. You tell the jury that his attempt to go out and look for injured people was a really bad thing to do. Yeah, let's see how far you go with that, Binger.
He didn't. He was isolated.
He was isolated. He got separated. That's not his fault. And when he did, he tried to go back to the garage. The police wouldn't let him go past the barricade. It's on video.
He was cut off from the rest of his crew. He was running around with an assault rifle type weapon, a very threatening, aggressive weapon, one that deters people. It is designed to deter people. It is designed to threaten others, to let them know, don't mess with me. Look what I've got.
That's right. You carry the rifle to let people know, don't mess with me. That's the way you stop things from happening in the first place. Keep in mind, Kyle was the only one that opened fire that night. Now, what if Kyle had carried it concealed? You think he would have changed his tune? He would have said he carried it concealed so people couldn't tell that he was actually armed, and then he surprised them.
Other people that night are carrying around semi-automatic pistols, Glocks, which you can conceal and hide. Other people can't see it.
Yeah, that's right. That's supposed to be a virtue in this kind of situation? Carrying a concealed pistol around in a riot? Okay.
It's not designed to tell people go away. It's not designed to tell people leave me alone. You carry around an assault rifle like this, you're sending that message to other people. That's what the defendant was doing.
Obviously, they didn't get the message. That's their fault.
Running around in all this, taking on this responsibility, which he had no lawful authority to do, and making assumptions about what Mr. Rosenbaum was going to do next, or what he shouldn't have been doing, and then confronting Mr. Rosenbaum about that.
His assumptions were probably right.
That is the context here, Your Honor. And the August 10th incident is exactly the same in that respect. Exactly the same in taking the law into his own hands with the same gun, making assumptions about what other people are doing, and taking responsibility to try and stop people when you are not trained, you're not a law enforcement, you're a teenager. It's not his job. So it's exactly the same fact scenario, Your Honor. And I apologize for not making this clearer in my motion, but I think when you look at it through that perspective, Your Honor, you can see why this goes exactly to motive and intent. Now, you say it's proclivity evidence, it's propensity evidence. It shows a motive and intent to be a vigilante that night and take the law in his own hands and use deadly force to stop people who are committing crimes that no one is allowed to use deadly force to stop.
The last statement he made was his best one. If he would have centered everything around that, might have had a chance.
Police officers are not allowed to shoot shoplifters. Police officers are not allowed to shoot people who are about to set a vehicle in a used car lot on fire.
Yeah, but I bet a lot of police officers hanging out in a bar say a lot of things like, if I had my car, I would have ran him over. Yeah, everybody says these things.
You don't get to use deadly force in those circumstances. You don't get to threaten deadly force in those circumstances. So what Mr. Rittenhouse was doing was well beyond what even the police could have done that night. He took it upon himself. And that is unlawful. It is unjustified. That's what we're talking about here. So that's the exact similarity between those, and that's why the state's asking that the court allow the jury to hear this, because it goes to his state of mind. It shows that he is the type of person who will act to take the law into his own hands. The defense will give their side of the story. They will portray the defendant as this altruistic young kid who came here to try and help. The jury can make the decision.
Yeah, their evidence is going to be based on what happened that night, unlike yours.
But let's give them the full picture here, and they can make a decision with the court's limiting instruction on this other acts issue. The jury can make a decision here as to what the intent and motive of the defendant was, what his subjective beliefs were, and whether or not they were reasonable. But this information is crucial to the jury being able to make that decision.
It really is crucial. So if your motion is denied, then you have no choice but to drop the charges, right? Quit saying crucial.
And they deserve to hear it, along with everything else that's going to be submitted by the defense that's going to portray the defendant in a rosy, innocent, altruistic light. Let's have the full picture here. That's
Well, why don't you take the events of that night and use that to show that Kyle's an evil bastard? Can't. That's the problem. You don't have any such evidence.